Good morning and good afternoon to wherever you're joining us from today, and welcome to this week's edition of the myHR Minute. My name is Dan Johnson. I'm the Director of Marketing and Customer Experience here at myHRcounsel. I'd like to thank you all for taking the time out of your day to join us and for your continued interest in our now weekly webinars. As a reminder, we will be recording this webinar and we will send over a follow-up email tomorrow, which will include the recording, the slide deck, as well as the HRCI or SHRM recertification codes. Additionally, we'll be including a link to a survey which we would really appreciate you taking the time to complete. The results of the survey will help us improve our webinars as well as allow you to recommend any new topics that you would like us to cover in upcoming webinars. Next week, we will be covering a new topic, quiet quitting, which you may have heard of. We have included a registration link in the chat box below. And now I'd like to introduce our speaker for today, Britt Waterman, who is one of our senior attorneys here at myHRcounsel.
Thanks, Dan. Well, welcome everyone. It's good to have everyone here on the line. And today we're talking about workers' compensation. I think there are a lot of sort of myths and misunderstandings about workers' compensation, and I just want to give a little background, a little kind of tips and dispel some of the myths and kind of reveal some of the traps, some of the things that can get you in trouble with workers' compensation, and address some of the common questions or issues that I get related to workers' compensation that I see on tickets related to the subject. So just some basics. So workers' compensation is not money out of your pocket. So it's an insurance policy, and your rates are calculated by a base rate, and the base rate is set by both your state and by the occupation or your industry, and it's multiplied by an experience rating. So the more claims you have, the higher the experience rating goes and the higher your rates get. That's an incredibly simplified explanation of the experience rating, but that's basically it. So employees cannot waive liability for any injuries that happen at work or work-related events. I get that question a lot. Can we, we're doing this work event, can I have employees, can you draw up a liability waiver? So employees cannot waive liability for injuries that happen at work or work-related events. There's nothing to waive because they cannot sue you. But any injuries that happen will be covered by workers' compensation, and workers' compensation can never be waived. You cannot have an employee draw up a waiver saying that they will promise not to file a workers' compensation claim. We can move on to the next slide. So state law, so workers' compensation is mainly governed by state law. There are few federal laws, but mainly it's kind of reined in by the states. A workers' compensation policy is required in every state except Texas. State laws vary on how many employees you need to require a policy. Some states say you have to have a workers' compensation insurance policy, even if the only employees are the two owners of the company. Other states would say you would not have to have coverage in a case like that. All states are going to require you to report workers' compensation claims to the state. Even in Texas, where you can choose to purchase a policy, or you can just choose to pay the costs of a worker who becomes injured, you still have to report those workers' compensation claims to the state of Texas. Some states require you to purchase your policy through a state fund instead of through a private insurance company. There are a few states that do that as well. So you should know your state. If you aren't sure about your state, certainly open a ticket with us and we can advise you on your specific state law. So injuries or illnesses not covered by workers' compensation. I get questions on this a lot. This is a list of things that would not be covered by workers' compensation. An act of God if your employee is struck by lightning, that's not going to be covered. Injuries relating from intoxication or drug or alcohol use, that's a question that I get a lot. That's something you need to document very carefully, because your insurance company is going to want to see all of the documentation you have when they're deciding whether or not to cover a claim. So if you believe that someone that intoxication or drug or alcohol use has contributed to the injury, and your drug testing policy should say that if you believe that, if you have a reasonable suspicion that alcohol or drug use contributed to the accident or the incident, that you can order a drug test in that case. If you should have that in your drug testing policy, you should drug test at that point if you think there is a reasonable suspicion that drug or alcohol use was involved, and you should document both your observations and the drug testing for your insurance company. Illnesses such as colds and flus. I know there's some issue with COVID of some states making COVID a workers' compensation illness, which is a little different than colds or flu. That again is kind of differs with state law, and that is more common with employees who deal directly in high-risk occupations, and they have to prove that the COVID was caused by workplace exposure and not some other exposure. But generally, colds, flus, those type of illnesses are not covered by workers' compensation. So workers' compensation covers illness or injury that are arising in the course and scope of employment. So let's break that down into two parts. So arising out of would mean that the risk to this person would not have existed had they not come to work. So there would have been no risk of this injury happening had they not done their job that day. So a risk at work would be an uncaged ladder, a slippery floor, if they're working with a non-ergonomic keyboard and they can get a repetitive stress injury like carpal tunnel syndrome, something like that, a company vehicle that gets in an accident. Things with a repetitive stress injury like carpal tunnel syndrome or tendonitis, something like that. That's a little more difficult one to parse out, but basically, if they are doing something repetitive at work, that wouldn't have happened if they weren't doing something repetitive at work. If they had just been at home, that might not have happened. So that could be arising out of their employment. Course and scope means, did the injury happen within the time and space boundaries of you, the employer? Remember, a remote worker's job site is your job site. If they're working from home, their home is your job site. Doing business at a client site, when you send your employees to a client site, that now exists within your space boundaries. Company-sponsored events. This includes holiday parties is a big one, a question I get. If we serve alcohol at the holiday party and an employee gets in a drunk driving accident on the way home, are we liable? Yes, that injury is going to be to the employee. An injury to the employee is going to be covered by workers' compensation. Are you going to be liable if someone else is injured? Yes, you will be liable for that as well. So you need to be watchful as far as providing alcohol, but company-sponsored events are covered by workers' compensation. Travel, going to from job site to job site, whether in a company vehicle or a personal vehicle, is covered. If your employee drives a personal vehicle and gets in an accident between job sites, it's still covered. taxi to the airport, tripping over luggage in the terminal, whiplash from turbulence on the plane, employee slips and falls on the way to the hotel ice machine, employee goes out to eat on the business trip and is burned by hot soup in the restaurant. It's all covered by workers' compensation. As long as the employee is doing something that they would need to do to accomplish your business, any injury is going to be covered. Injury on a regular home to work commute is not a workers' compensation injury, but if you tell an employee to swing by Office Max on the way to work and they get in a car accident on the stretch of road that takes them out of their way to Office Max between home and work, that accident's going to be covered by workers' compensation. Now, the kind of the determination on whether driving in a car or driving to and from work is going to be covered is whether it's a detour versus a frolic. A detour is something that is a company business. A frolic is a personal errand. So a detour, picking up donuts for the staff meeting. A frolic, going to Starbucks for yourself. A detour is covered. A frolic is not. A detour, going to the UPS store to get poster board and markers to create a presentation. Even if a manager did not tell the employee to get the poster board, if they're going to use it for work, it's a detour, and if they get injured, it's covered. Stopping by the UPS store to print labels for Christmas card, that's a frolic, that's not covered. So that's an example of that. Excessive celebration, not just in sports, also in your work environment. This may seem like you're incentivizing safety, but OSHA sees this quite differently. They see this having a chilling effect on reporting injuries. Maybe someone gets injured, but they do not want to be the reason that no one gets a pizza party or the company has to take down their sign. And you want to encourage employees to follow the rules, but you should take the tactic of disciplining employees who don't follow the rules rather than something like this, that an employee may just try to walk it off if they know that that they're going to be the cause of other employees' disappointment. Some employees follow the rules to the letter and still get hurt because of someone else's carelessness or malfunctioning piece of equipment. You don't want those employees to not report their injuries because they want to be safe employee of the month. So create a culture of safety. Don't tangle with OSHA and your state's DOL. Your employee who walks it off now is only going to make it worse. And so discipline those who violate safety rules, but don't do this. And I see we're kind of getting close on time here. OSHA has come out and said that you cannot require an employee to report an injury immediately. You must require the employee to report as soon as practicable. Your handbook should not say immediately. It should say as soon as practicable. Your policy should not say report within 24 hours or discipline. If your employee gets injured and isn't sure if it's a big deal and makes a doctor's appointment for 48 hours later, you don't want them to not report the injury because they are afraid they're going to get in trouble for not reporting it within 24 hours. You can still have a policy requiring employees to report safety hazards immediately. You can discipline someone for walking past a chemical spill 10 times without reporting it to a safety manager. OSHA record keeping, even if the claim is denied by your insurance, you still have to report it to OSHA. Disability discrimination. If you have a forklift operator who tells you they have a seizure disorder that may pose a direct threat to safety, you should not think work comp injury waiting to happen, get them out of here. You should go through the interactive process. You can require an employee to report medication that may affect their ability to perform the job safely. But again, you go through the interactive process. You don't worry about a workers' compensation and let that employee go. An employee who comes back after a workers' compensation injury may now have a disability. You must provide a reasonable accommodation. You cannot say all better after your work comp injury, or you're fired, or set a time limit on light duty if light duty is still a reasonable accommodation for that employee. And just to finish up on retaliation, yes, it is possible to terminate an employee on workers' compensation, but it is risky. The timing always looks bad for you. You cannot terminate someone because they made your rating go up, or because you are afraid that if you let them back on the job, they will keep making claims. Your fear of a serial claimant is not a reason for terminating an employee. Unless if your insurer can prove that the claim was invalid and made in bad faith, that can be a reason for termination. But just because a claim was denied is not a reason for termination. Reasons for termination that are not because of the claim: failing a drug test, refusing to use PPE, that may have caused the accident that resulted in the claim, but those are valid non-retaliatory reasons. And your insurer is the one who investigates the claim, not you. They're fine merit if they don't. You are not responsible for spying on your employee and terminating them because you think they are faking. Let insurance take care of that. If you terminate based on your opinion without letting your insurer do the work, it could be seen as retaliation for filing the claim. And that concludes our myHR Minute today on workers' compensation. If you have questions about workers' compensation or about any HR and employment law matters, please open up a ticket in our Ask an Attorney portal. If you are not one of our clients and you have questions about your state law with regard to any HR and employment laws, please go to myHRcounsel.com or email info@myHRcounsel.com. We'd be happy to tell you more about our packages. We can take you through a demo. We can show you all of the services that we provide and how we can help you stay legally compliant both on workers' compensation and all other matters HR and employment law related. So thank you all for participating today, and have a great rest of your day.